Okay, it's 2 minutes after 1 o'clock and we're up to 72 participants out of about 80 plus who said they were going to join. So I think we'll get started. We've got some intros anyway for anybody else joining in a little bit later. So let me just share the PowerPoint. I'm afraid this is the first time in real life I've been doing this. So if you'll just give me one moment. And then we can get started. Okay. Right, okay. Good afternoon, everybody, and welcome to another seminar in the King's Employment Team Friday 1 p.m. seminar slot that we've taken on during the lockdown period. Thank you all for joining us. We are recording this seminar and it will be made available on the website as we have done with previous seminars. And if there's anything that you've missed in the past that you'd like to go back and look, I believe they're still available on the website. We'll also be distributing these slides as an online handout, I suppose, after this seminar to those of you that have participated. So that information will be available for you as well. Just a few housekeeping issues before we introduce ourselves. I think I've now managed to mute all of your microphones, but if you think that's wrong, if you could just pop yourselves on mute, it stops any interference of noise as we go along. Please do bear with us. We've done quite a few Zoom seminars and there are sometimes little glitches in the audio, but on Zoom it does seem to tend to catch up with us. So you shouldn't miss what's being heard. If you do and you need anything repeating, if you could just communicate with us in the chat function, which should be along the bottom of your screen, a button to open chat, and then it usually opens as a column on the right hand side, and you can communicate either with everybody or you can send a message to Helen or I individually. I think it should be in the top left hand corner of your screen where you can choose to select speaker view. If you do that, then it will switch between myself and Helen as a thumbnail that you should be seeing as we're talking. As I said earlier and as went out in your emails, if you'd like to submit any questions, the best way for us to do that is on the Slido website, and it's got the code there, 334455. You can also submit questions during a talk in the chat function, but we've only got the 1 hour slot today. We can't run over, I'm afraid, so we'll be prioritising the ones that have already been submitted on Slido first. But if we don't manage to get back to you during this session, we'll try and follow up in emails afterwards, so long as we can get the necessary information off chat. Please also, in either the chat function or in emails afterwards, let us know if there are any topics you'd like us to talk about. As I say, we're at least trying to do one session a week on the 1 p.m. on a Friday. So if there's anything you'd find particularly useful at the moment, do feel free to let us know. And feel free to give us feedback afterwards about the content of what we've been talking about, but also any particular issues or anything you found useful from working with Zoom. So for those of you who've been on these seminars before, you'll know me. I'm Laura Gould. I'm a member of the Employment, Business and Property and Sports Law teams at King's Chambers. My practice is predominantly employment work and employment commercial, and I do have a pure insolvency practice, but I'm often instructed in matters where it overlaps with my employment expertise. So before Furlough and the likes, that was in TUPE matters most often. So I'll just hand over to Helen for her to introduce herself to you as well.
Thanks, Laura. Hi, I'm Helen Gardner. I'm a commercial barrister in the business and property team. I've also got quite a busy employment practice, and like Laura, much of my practice involves looking at the overlap between the two areas, often in terms of business recovery and TUPE, but particularly at the moment with regards to furloughing. And there have been two very recent High Court decisions which fall squarely in that overlap, and that's what we're here to talk to you about today.
Thanks very much, Helen. Yes, Furlough and Administration. We've called this Carluccio's talk, but time and the law waits for no man. So we're talking to you about the Debenhams decision from a couple of days later as well. Basics of Furlough and Administration. I know a number of you on the call are employment lawyers and hate the F word already. It's not been far from our lips or our WhatsApp fingers or our emails. We're not going into the detail of what the furlough scheme actually is today. We gave a seminar, I think it was on the Thursday before Easter, on the furlough scheme. We'll likely be doing one updating you in light of the new guidance. So you can have a look on our website for that and our blog to keep up to date on what we're talking about there. So that's the government's coronavirus job retention scheme. So anywhere that I mentioned CJRS, I'm talking about the furlough scheme there. In terms of administration, we're looking at paragraph 3(1)(b) of Schedule B1 of the Insolvency Act of 1986. So anywhere in this slide or the talk where we mention IA 1986, that's the act that we're talking about. And in terms of administrations, particularly those employment lawyers amongst you will tend to know that in the CHUPE context, looking at when something is in administration, when it isn't, and therefore what elements of CHUPE do or don't apply. And for these two cases, we're particularly looking at the second aim of administration. So that's the second bullet point from the bottom there, where it would achieve a better result for the company's creditors than would be achieved under a winding up, and apologies, that should say order. So furlough, it's something that's fairly new to most of us, administration less so. In terms of the overlap, as Helen and I have said, it's an area that we work in, but we tend to work with different sets of solicitors depending on what side the matter's coming from, whether it's coming from an insolvency side or employment. But I think people are becoming more alive to the overlap of these two areas. And I think that can only be a growth area in advisory work, and eventually, as these matters often become, contentious work. These are some statistics from a British Chamber of Commerce survey that was published on, I think it was Wednesday of this week, so only 2 days ago, where the figures had increased from a previous survey, saying that now more than 70% of firms had furloughed staff. 59% of firms have declared that at most they have 3 months of funds in reserve, and 30% of firms that have furloughed staff have furloughed 75 to 100% of their employees. Now, I don't think those figures will actually surprise us, whether you've advised in this area or just anecdotally from knowing friends that have been placed on furlough or from looking in the media, but it's clearly an area that we really need to get to grips with, because you can see from that second bullet point, furlough isn't necessarily going to save all the companies that we or the government would hope it would. So looking at the first of the two key decisions in this area, and I'm going to talk you through the Carluccio's decision. The title is there, so when you get the handouts, you can go and find it and have a read for yourselves. It's the decision of Mr. Justice Snowden, and if you have any specific issues in this area, I would encourage you to read the decision. It is very accessible, as is the Debenhams decision as well. The judges haven't shirked any matters, I don't think, particularly. They've tried to engage with all the arguments to provide some guidance to practitioners, and it is written in a clear and digestible way. So whilst I would encourage you to speak to Helen or I if you've got any particular concerns, don't be afraid to have a look at the decision yourselves. So here it was an application by administrators for a declaration made under paragraph 63 of Schedule B1. Why was this done? Well, you'll have all no doubt heard about Carluccio's being in some difficulty for a while now. And as at 16th of March, when the shutdown happened, all 70 branches were closed. They have in the region of 1,800 staff members, and given the financial difficulties that they've been placed in, which are no doubt exacerbated significantly by the shutdown, an administration order was made on the 30th of March. Now, the government's stated intention, and I do place that emphasis because we know that the original guidance hasn't necessarily been borne out in the later iterations of the more detailed guidance, but their original guidance confirmed that the CJRS would enable employers, including those in administration, to furlough employees where their services could not be used. So it was explicitly stated as intending to deal with those in administration. The reason why this application has been made so soon into matters is there was an urgency from the administrators related to what we call the safe period. And this is the first 14 days from the appointment of the administrators when they can take actions in relation to employees in the contract of employment without having been taken to adopt the employment contracts. So that's why you'll see me in talking about this case refer to the first 14-day period on a number of occasions. So further details as to why this case came about. Carluccio's had no money to pay wages. The only way that they could pay wages was by using the furlough scheme, in combination with limiting the liability for the wages to 80%, or the maximum of 2,500 as per the government scheme, and providing that the wages would only be paid to employees upon payment by the government under the furlough scheme. If that didn't happen, then redundancies were going to have to be made. And clearly the spirit of the furlough scheme is to avoid redundancies where businesses are potentially going to be able to reopen after the lockdown. Now, redundancies in this case wouldn't just be bad for the employees, they'd be bad for the sale of the business. And of course, as we looked at administration, you're looking to sell the business as a going concern, keep it going here until it can be sold, albeit in these difficult times. You want a reliable, long-standing workforce to be able to do that, so when matters reopen, they can pick up where they left off. Now, the scheme guidance stated, as I said earlier, that administrators would be able to access the job retention scheme, but it also stated that it should only be accessed where the administrator thought there was a likelihood, a reasonable likelihood of rehiring the workers. That was accepted to be the case in Carluccio's, where evidence was put before the court of a number of interested buyers, or certainly that was referred to and accepted as being the case. So one envisages, that's probably a public policy point, but also just seeking to look at what's the purpose of the particular administration. Here it's got to be looking to reopen the business again, most likely after the lockdown is lifted. The plan of the administration was a classic mothball strategy with an intention to sell the business. As I said, they wanted to retain the employees to be able to do that. But of course, the administrators have to focus on the best results for the existing creditors. So they were looking only to retain the employees if the liability for the wages fell to the government rather than Carluccio's, which was insolvent or is insolvent. So in terms of the actions of the administrators, here again, I'm focusing on what happened in those crucial first 14 days of the safe period. The administrators made offers to the employees to place them on furlough. And of course, we knew right from the outset that it needed to be an offer made to furlough that needed to be agreed as a variation to a contract. It couldn't just be imposed upon an employee. Obviously more recent guidance about what exactly needs to be set out in writing, but certainly Carluccio's followed what they needed to do at the time. This was still early in the furlough guidance, and the judgment does actually recognise the limits to that guidance at the time. Unfortunately, we've not been provided with any more in respective administrations at this stage, but we'll come on to look at where we might be heading. The overwhelming majority of the employees accepted the proposal of the reduction to 80% pay, which would be paid once the monies had been received from the government, and there was an expressed intention to pay within 7 days of receipt, but it wasn't set out that that was a definite term. 4 individuals rejected and sought redundancy, so didn't agree to the variation of their contract, and there were a number of other employees, about I think it was 77, who hadn't responded. But actually, if you look at the timelines of this, that's not as surprising as you might think, bearing in mind the case was heard from the 6th to the 9th of April, and the administration order had only been made on the 30th of March. Note that the hearing was actually held by video link, and apparently really quite successfully, and that's quite a long length of hearing to do that. So positive to see that that is happening already in our higher courts at least. So the variation letter that was sent, again, was sent within the first 14 days. This is where the terms of the offer are set out by the administrators. So they are taking action in relation to employees during that first 14-day safe period, when it can't count towards consideration of whether the administrators have adopted the contract of employment. The Carluccio's case found that there was a variation of the contract where this the terms of the letter were accepted, but it found that there couldn't be implied acceptance for non-responding employees. There was a review of the case law in that area, and I've given you some of the paragraphs in case you need to jump straight into that point, and a review of the recent and very helpful case that provides an overview in this area of Abram Hall and Nottingham City Council as to what it takes for implied acceptance. And the judge ultimately found it couldn't happen here, particularly given the length of time, but also, and I think this is noteworthy for all of us, whether you're looking at administration or not, because the letter stated that if employees didn't accept the variation to their contracts, then the likelihood was they would be considered for redundancy. So it didn't say to them, if we don't hear from you, you'll be taken to have impliedly accepted this variation. It said exactly the opposite. And so the judge did reflect, Mr. Justice Snowden reflected, that if it was a different letter with a different time period, potentially there could be implied acceptance. So I think that's something worth for us all to note. As I say, the terms that were proposed and accepted by the majority were that the administrators and company would not be liable for wages or salary in excess of the 80% recoverable under the scheme, and they would only be paid when the funds were recovered under the scheme. So what issues arose here? Well, quite a few. That's why everyone's been talking about it. To start with, the actual money paid under the furlough scheme, probably as many of you will have experienced now in actually accessing the portal from Monday of this week, has to be a claim made by the employer for payment of income to the employer. So it's taxable as income received by the employer, and it gets paid into the employer's bank account. There's no requirement to separate out those funds, but there is the requirement under the scheme that the money is eventually paid to the employees for whom the claims have been made. But in an administration context, that means that there's money being paid into an employer's bank account or company bank account, where a company is in an administration, making those assets of the company in administration. And the administrators can't just go, oh, well, that was paid in because it was money for the employees, so we'll just pay it straight out. There are orders of priorities that they have to consider in relation to their own expenses, secured creditors, depending on the basis of which they're secured, moving down to the usual claims by employees as unsecured creditors with provable debts. So this is where one of the main problems has been created. Now, the furlough guidance hadn't at the time of this case, and unfortunately still hasn't in the latest Treasury guidance, given any provision for holding money on trust, which is a potential way to get around the order of priorities. Mr. Justice Snowden touches upon the cases which would be helpful in that situation in his judgment in Carluccio's, but he notes that nowhere is there any mention of trust or really anything which could draw an inference that the money could or should be held on trust, but that this is a potential way out. So one hopes that the Treasury will be looking at that as to a potential solve with providing a bit more clarity in this area, but it hasn't happened yet. So the case was needed to look at how payment could be justified of wages in priority to other claims against the company. And in doing that, there were two paragraphs in particular of Schedule B1 that were looked at. Paragraph 99, which where we talk about super priority of wages and debts, and paragraph 66, which we sometimes look at as a sort of a plug the gap paragraph. So paragraph 99 created a lot of the discussion in this case, because that talks about adoption of contracts of employment by the administrators, creating a super priority of wages. And that means it's payable even before the fees and expenses of the administrators. In this situation, what does wages include? We always like a debate about what wages mean. Here it would include holiday pay. Can't quite help you on that at the moment, as we've still not had any more guidance to help set us straight on holiday pay. And it can also include contribution to occupational pension schemes. What it doesn't include, and I think this will make sense for people who've dealt with employment claims in this area, are redundancy payments, unfair dismissal payments, payments in lieu of notice, or protective awards. And of course, they're the sorts of things that we normally look at going to the Secretary of State's National Insurance Fund to be able to make claims in respect of. If an employment contract is not adopted by the administrators within the or after the first 14 days, then the claims of an employee merely become unsecured provable debts, so they're way down that order of priorities. Paragraph 66, which I think Helen will touch upon as well, as I say, potentially provides some scope to plug the gaps, and she'll talk to you about where that might be useful. In terms of paragraph 99, that's what I'm particularly going to look at under the Carluccio's judgment, and the Paramount case, as it's called, which Lord Justice Brown Wilkinson gave the main decision in relation to adoption of employment contracts in this situation by administrators. There again, I've given you the paragraphs from the Carluccio's case that are particularly relevant if you want to jump straight into this point. But a few overarching principles that are worth noting. Employment of an administrator itself does not terminate employment. I think we all know that, but it's worth getting back to the basics. The mere continuation of the employment by the company does not inexorably lead to the conclusion that the contract has been adopted by the administrator or receiver. That is to say, as we're going to look at, something more has to happen, albeit it doesn't necessarily have to be a huge leap. An adoption, once it does happen, is an all or nothing concept. So you cannot pick and choose liabilities to be bound by or conditions to apply for adoption. Now that's when adoption does take place, as opposed to in Carluccio's, where you can see the variation of the contract has occurred in the 14-day safe period before actions of the administrator can be taken to count towards adoption. So if you're advising at a really early stage here, worth bearing that in mind. So some commentary from the Paramount case here. I'm afraid I don't think I've given you the paragraph reference, but here it's talking about earlier iterations of the paragraphs, talks about what does happen in terms of priority and adoption, and it's particularly relevant there, the quote I've underlined where it says that adoption can only be connoted by some conduct of the administrator or receiver which amounts to an election to treat the continued contract of employment with the company as giving rise to a separate liability in the administration or receivership. So it's not saying the administrators are personally liable for the employment wages, the contracts, etc., but it's bumping them way up in the order of priorities. And that doesn't happen just by passage of time, but instead an act needs to take place or some conduct which connotes that that's the intention. So in a normal situation, the conduct on the part of the administrator is likely to occur when the administrator communicates to the employees that actually the business does remain open and the employees should attend for work in the usual way, as opposed to have them all in a meeting and tell everyone to go home and that's that. Now, that might sound as though it's a very minimal step in terms of adoption of the contract, but one of the really helpful ways to understand all of what we're talking about today and those scenarios is that second bullet point I've put in there, which is to look at what was the mischief that was intended to be avoided by the law developing in this way. And that was the mischief of administrators coming in, saying to the likes of Carluccio's staff, if let's say the business was remaining open, don't worry, we're going to keep running, keep turning up for work, keep serving people, making great coffee, etc. And we will pay your wages. This is how we're going to sell the business. We will make sure your wages are paid, and then turning round and trying to avoid that payment, saying, oh no, sorry, you're just an unsecured creditor, go and prove your debt against the National Insurance Fund, we can't help you. So that's the normal situation that the law is looking to avoid happening. And it still helps to put into context matters under furlough. So what was concluded, looking at that and analysing it in this case? Well, in relation to the individuals that you'll probably be most interested in, the consenting employees who consented to the variation of the contract that was offered within the first 14 days, the judge found that varying the contract in the first 14 days or making that offer hadn't led to an adoption because it happens within the first 14 days. He also found, as we'll come on to look at, that if one of the non-responding employees accepted the offer to vary their contract after the 14 days had elapsed, that in and of itself would not amount to an adoption because it is not any action being taken by the administrators. they've already taken their action in the first 14-day safe period by making the offer. So there hadn't been an adoption yet, and bear in mind this decision occurs within the first 14 days, so there can't have been. When did Mr. Justice Snowden consider that adoption would take place? It was either when an application is made under the CJRS furlough scheme, whatever you want to call it, for this money, or if money unexpectedly became available that could be paid to the employees. Second one, less likely to happen, it seems, and we're focusing on furlough today. And that was because he said the administrators would be doing an act which could only be explicable on the basis that they were electing to treat the varied contract as giving rise to liabilities which qualified for a super priority. Now again, useful to read the judgment, but think about this in the context of everything we know about the furlough scheme, not just the guidance, but the spirit of the scheme. It strikes me it cannot be right from an HMRC perspective to be applying for money under the furlough scheme, knowing it's just going to go into the pots for all creditors, because we know the scheme says the money received has to be paid out to the employees. And so as soon as you make that application under the CJRS, you can only be making that application with the intention that that money is then going to be paid to the staff members who you are making the application for. It would absolutely fly in the face of the intentions of the scheme and public policy if creditors were being paid out of money that has only been established as a fund to be paid to employees. So the problem really is here just making it fit with the insolvency schemes and the relevant rules to make sure that the intentions of the scheme are followed through. Obviously there wasn't quite enough time to think about that before the guidance originally came out. So again, we're thinking about it from that perspective when you're trying to problem solve in this area. The judge did find, however, there was no duty on the administrator to apply under the scheme. He didn't go into a detailed analysis of any duties created by the variation of the contract, but ultimately concluded in the situation as it presented to him, the administrator wasn't duty bound. Whether any other liabilities might arise thereafter, I haven't particularly turned my mind to it at this stage, but if that comes up as a problem, worth looking at the views of Mr. Justice Snowden on that point as a starting point. Paragraphs 93 to 96, there's only, I'm afraid, so much we can go through in the time available to us, but that deals with attempts in the original variation letter to exclude adoption by the unilateral wording from the administrator. That's old school, it can't work anymore. The judge said it was a mistake to include it. He did briefly look upon whether that would be whether that could make a difference, but ultimately, whether adoption happens or not, talking about the previous mischief, that was to avoid or overcome the difficulties that have been created by these sorts of unilateral exclusions. So again, if you have that as an issue or you've tried to include that as in a letter, have a look at what Mr. Justice Snowden says about it in those paragraphs. The objecting employees, so as I said, confirmed they wouldn't accept the variation, were not varied, were not adopted, and were unsecured debtors. Creditors, apologies, with approvable debt. And the non-responding employees, there hadn't been a variation of the contract, albeit there could be if they accepted the offer prior to termination, and so they were still unsecured, ranking down near the bottom end on the order of priorities. Couple of comments to take from the judgment on future potential steps. Paragraph 35 there is the point I referred to on trusts, so hopefully we might see some movement in that direction. And Mr. Justice Snowden repeated what was said in Paramount, recognising that it was quite inadequate, the initial 14-day period for the administrators to be making these decisions. Whether that has a knock-on effect on collective consultation, I'll come on to comments in a little bit later. In terms of the limits, Mr. Justice Snowden recognised at the outset in paragraph 7 he didn't consider this decision would be binding because there were no representative employees. The only interested party other than the administrators was Unite. They were able to get involved because they represented some of the employees, but given the time limits, they hadn't actually been able to consult with their own employees. So They provided an overview of the issues as they could see it and some detailed analysis and assistance in relation to employment contracts, but perhaps not as thorough as they might have wanted to be if they'd been able to give some examples following consultation. That being said, as I said at the outset, it is a very helpful decision and well worth looking at for guidance in this area, albeit there have been some discussions in relation to appeals, I think particularly in relation to the Debenhams case. Whether that happens, we'll have to wait and see. No doubt they'd be looking to move extremely quickly for some of the reasons we've already looked at. So what about the next case, Debenhams? Helen?
Thanks, Laura. The Debenhams case was heard on the 15th of the month. Judgment was given on the 17th. In between those two dates, a Treasury direction was issued, but that doesn't go anywhere towards discussing issues in administration, and it certainly doesn't answer the questions about holding the money on trust that was raised by Mr. Justice Snowden. So these cases are still going to be very much at the forefront of administrators' minds. And just like with Carluccio's, this was a case that was advisory. It's not binding precedent for the same reasons people who should have been able to advocate weren't. But again, that's down to the very strict timescales that the administrators were working to. It's no secret that Debenhams had suffered significant financial difficulties for quite some time. The former holding company of the group went into administration in April 2019. And shortly after that, this company and its sister company entered into CVAs. Now, having weathered that storm, the company was then forced to close all of its 142 stores following the government's restrictions in relation to the coronavirus pandemic. Its only business which continues is its online retail, and that accounts for about 19% of the business. On the 25th of March 2020, the company wrote to approximately 13,000 of its employees, informing them of the decision to furlough them and pay only 80% of salaries. Now, you'll notice it was that they were informing the employees they weren't seeking agreement. The action reflects the government guidance that was in place at the time. It's since been revised a few times, and that was that the company must notify employees that they were to cease work and they were being furloughed. The updated guidance requires agreement. That's reiterated by paragraph 6.7 of the Treasury direction that was issued on the 15th of April. Administrators were appointed on the 9th of April 2020, and by then another 867 employees had been furloughed on the same terms. The plan of the administrators, similar to Carluccio's, they planned a light touch administration where existing management would continue to exercise certain operational powers whilst the administrators try to stabilise the business. The intention was very much to rescue the company. Strategy was to mothball, and the key aspect of that strategy was retaining the employees. When they were appointed, the administrators quite sensibly took the view that they should obtain express consent from the furloughed employees to this reduction in their wages. They wrote seeking consent, and by the time of the hearing, approximately 12,700 had consented, 4 had objected, and 359 had failed to respond. The judgment doesn't contain the content of the agreement or the correspondence by the administrators. We know that in Carluccio, the agreement was to pay 80% of pay when the funds, if and when the funds were received from the government. Debenhams' plan was different. It was to pay employees out of cash reserves and then be reimbursed by the job retention scheme. Now, my own view is, with hindsight, had they framed the agreements in the same way that Carluccio administrators did, their concerns might have been allayed somewhat, but hindsight's always a wonderful thing. The administrators were concerned that by continuing to furlough employees, contracts of employment would be adopted, and following Carluccio, all of the employees' wages and salary entitlements would obtain super priority. The figures in the judgment say that that would give rise to an exposure of about £3 million a month, subject to deductions for the consenting employees. And of course, there's a risk factor here because of the way the company had had affected the furloughing in the first place, where there hadn't been an express agreement to reduce to 80% wages. If the contracts of employment were adopted, then the administrators would be adopting the liability for 100% of salary, with only 80% being recouped from the government. They were also concerned, quite understandably, about how holiday and sick pay would be treated. What the administrators said was that adoption of the contracts and imposition of super priority would have significant negative effects here. One, for the company, because it would deplete the assets, and two, it would have a negative consequence for employees, because administrators would be forced to make redundancies so as to avoid the risk of that liability. And they pointed out that that would have an adverse impact on the wider rescue culture which underlies the administration regime. They sought guidance on whether simply continuing to furlough would amount to an adoption of the employment contracts. They sought a declaration that it wouldn't, and they argued that Mr. Justice Snowden had been wrong to invoke paragraph 99 of Schedule B1. That's the one which makes provision for super priority. He should, they said, have relied upon paragraph 66, which Laura referred to, and that allows an administrator to make payments out of the order of priority where he considers it's likely to assist the achievement of the purpose of the administration. Mr. Justice Snowden had said in the Carluccio judgment that paragraph 66 would plug some gaps for, like Laura said, paying a supplier that needed to be paid. But the starting point, he said, was when you considered wages, you had to start with paragraph 99 because it explicitly talks about wages. Mr. Justice Trowett in Debenhams agreed with that analysis and with the analysis of authorities concerning adoption of employment of contracts. He also agreed that the absence of any actual services being rendered by the employees in question didn't prevent the contracts of employment from being adopted by the administrators. Usually, as Laura touched on, if there is provision of services, that's a good litmus test. But he identified that there could be good reasons, not just COVID related, to retain employees without them providing services in order to ensure the viability of the future business and continue trading in the future. One of the examples he gives is if they have knowledge of a trade secret, for example. Mr. Justice Trowett didn't just adopt Mr. Justice Snowden's judgment. Because the administrator's arguments weren't put before Mr. Justice Snowden, Trowett examined the question in detail. He said that the administrator's criticisms of the earlier judgment missed the point. Mr. Justice Snowden had said that contracts of employment would be adopted by participation in the scheme and payment of the employees. The conclusion didn't depend on whether or not paragraph 66 also allowed payments to employees in priority to other creditors. Instead, the conclusion that contracts would be adopted allowed him to say that the administrators of Carluccio's were permitted, and in fact required, to make payment to the employees pursuant to paragraph 99 for super priority. Mr. Justice Trowett looked at the authorities on adoption of contract. He reverted back to Lord Brown Wilkinson's test in Paramount, which Laura's looked at, and that test of some conduct by the administrator, which amounts to an election to treat the continued contracts of employment with the company as giving rise to a separate liability in the administration. He acknowledged that that was a slightly different test to that described by Mr. Justice Snowden. He'd said that it was doing an act which could only be explicable on the basis that they were electing to treat the varied contract as giving rise to liabilities which qualify for super priority. But he also pointed out that the slight difference doesn't lead to a different result. And the difference, it seems to me, is that there's now no scope, and it's made perfectly clear by Mr. Justice Trowett, there's no scope for subjective intention coming in here. It didn't matter whether the administrators intended that they would be creating super priority or not, but that was the effect of their conduct. Participation in the JRS amounted to the necessary positive conduct for adoption to take place. It was acknowledged in this case that there was a risk that this finding could lead to administrators making more employees than would otherwise be the case redundant. But what really are the implications? If we look at Debenhams and if we look at Carluccio's, it's clear that the majority of employees are adopting a pragmatic they're agreeing to variations of their contracts so that only the varied liabilities for which the company would be reimbursed would be qualifying for this super priority. The key then, it seems to me, for employers, administrators and employers generally, is to obtain the proper consent to an effective variation of a contract. Care should be taken to explain to an employee their options. There's nothing wrong with stating that one of those options, if variation isn't accepted, may be that they're put at risk of redundancy. That does need to be done properly without any undue pressure on employees. But given the alternatives at the moment in this particular climate we find ourselves in, it seems likely that 80% of a salary will be an attractive option to all but perhaps the most long-serving employees who are going to have potentially large redundancy payments. Laura, can I pass back to you for looking at the impact of these cases?
Yes, thanks very much for that, Helen. One of the things that jumped out to me was, as I mentioned earlier, the potential impact on collective consultation. Now, really, we're looking here at collective consultation for redundancy, and that's obviously the far more likely circumstances that employees, employers, administrators, etc. would end up in here. For those who don't deal with collective consultation, when you're looking at redundancies, your concern is if you're making or potentially proposing to make redundant within a 90-day period, either 20 to 99 members of staff or 100 or more members of staff. Now, there's an awful lot more to it than that. Some of you will remember the Woolworths cases as to what it means to be on different sites, etc. So if you've got any concerns, do feel free to get in touch and ask for any advice on these points. But just looking at the basics of where this can arise, if you're proposing to make 20 to 99 employees redundant within the next 90 days, then there needs to be a 30-day period of collective consultation. If it's 100 plus employees, it needs to be 45 days of collective consultation. And apparently, I don't know if this is true or not, but I've heard it said that the reason why the date was given to extend the furlough scheme most recently was because a number of large employers were making noises about having to start collective consultation on the proposal of making redundancies within the next 90 days. If you fail to conduct this collective consultation, and usually what we see are whole-scale failures. As I say, administrator comes in, stands on the box in the yard, gets all the employees together and says, sorry, that's it, out you go, we're locking the doors. So we're usually looking at whole-scale failures, but it doesn't have to be that that's the case. If there's failures generally to comply with the collective consultation requirements, employees can apply for a protective award. And that is pretty punitive, and it's intended to be punitive. It's one of the very few areas of employment legislation that deals with punitive awards. And it's an award of up to 90 days of gross pay per employee. And if you think about the numbers of staff involved with Carluccio's and Debenhams, that's a huge potential liability. And actually one that's often overlooked in cheapy circumstances when people are looking at quite short-term or quick, should I say, takeovers. But that figure can be reduced where there's a special circumstances. I've put defence in marks because it's not exactly a defence. It can reduce the 90-day limit award, but it has to be special circumstances rendering the consultation impractical. Now, arguably, COVID-19 and a lockdown does that anyway, save that, as we can see in these two cases, they are businesses that have known they've been in trouble for a while. They've got the administrators in and they haven't just shut the doors straight away. They've been looking through the furlough scheme to avoid redundancies because, of course, that's the whole point of the furlough scheme. Now there's this guidance, albeit not necessarily binding, but clear guidance and well-reasoned guidance. It strikes me that it would be far harder for any administrators in future to say, well, we didn't know, now you've changed the rules of the scheme, there should be a special circumstances defence to reduce this liability, because it's been set out now what happens. So if there's a decision, we don't want to adopt the contracts of employment, we're going to try and avoid that by just making everyone redundant, there's a good argument for saying there shouldn't be any reduction there. That being said, of course, and as I referred to earlier, what we're looking at here is how to make the current insolvency provisions fit with the scheme, because ultimately it's money that has been made available for employers to recover, to pay to employees. It shouldn't be going into a pot available to other creditors, and no doubt there'd be uproar if that did happen. And so whilst there might be concerns about adopting contracts of employment, certainly in the Carluccio's case, where they'd varied the contract within that first 14-day period, seems to provide a fairly good route for protection of any liability to pay over and above what can be recovered under the furlough scheme. Helen, what about the conclusions that you've reached from looking at these two cases?
Well, whilst the decisions aren't binding, and they do tell us a number of things, we know now that the JRS definitely applies to companies in administration. And we know that administrators will be taken to have adopted employment contracts, whether they cause the employee to be furloughed or not, provided that they make the application under the job retention scheme. We know that having utilised the job retention scheme, the company's liabilities to furloughed employees obtain super priority. And we also know, particularly from the Carluccio's decision, that contracts can be properly varied before applying the term so that you can limit the liability of the company to the equivalent of the sums received under the job retention scheme. That leads then to a fifth consideration. It's perhaps not pertinent quite so much at the moment, but where cash flow is an issue and the payment of wages is an issue and it's delayed, that can give rise to claims for unlawful deductions from wages in the employment tribunal. If that's likely to be an issue, we don't yet know how long it's going to take for sums to be received from the government, although I think they're aiming for about 6 business days, but who knows? There's been a huge amount of claims gone in. Where a company has cash flow issues, those unlawful deductions claims could be avoided by varying the contract to reflect the timing of the liability to pay wages coinciding with the timing of the receipt of the government grant. That's something which might come more into play if this furlough scheme is extended further. And for the time being, it doesn't seem to me there's any reason why it wouldn't be.
Okay, so just bear with me whilst I just close down the sharing of the screen so I can come back and see if we've got any questions in the chat function. We have got 3 questions that have come through on Slido, so we're going to start with those. So we've got a question from MG of Leonard Curtis asking, how does a company with transferring employees covered by TUPE post 19th of March actually go about making a claim on the CJRS platform? Well, I'm sure you'll appreciate we don't actually input claims into the platforms ourselves, so we can only go on the guidance we've received. But I think in terms of what we're talking about today and any issues that there might be there, if you've got someone who's TUPE'd over, then you're taking their start date as their original start date, not the date that they transferred over to you. They've got the continuity of employment, so you should just be putting them in as an employee with the relevant start date from before they transferred over. So unless they started on the 29th of February or 27th, whichever way around it would be, 29th, they should be fine for being able to, for a claim being made on their behalf as an existing employee with sufficient continuity of service to qualify under the scheme. We've got another question from Lisa Smith at Clarion. If an employee is furloughed and an application is made prior to the appointment of the administrator, but monies are received after, is the administrator obliged to pay those monies to the employees? And I suppose more importantly, how can that be done? Helen, what do you think on that one?
Well, it seems to me that if the application isn't made by the administrator, it's made before their appointment, then that doesn't trigger the adoption of the employment contract. If the employment contract isn't adopted, then there's no super priority under paragraph 99. We've already looked, well, you in particular have looked at the difficulties about putting this money into the general pot. It's clearly not in the spirit of the JRS for this money to go to general creditors. Because employment contracts aren't adopted by the application, and those employees would rank as unsecured creditors. It seems to me this is precisely where paragraph 66 of Schedule B1 really bites. It plugs that gap. It allows the administrator to make payments out of the order of priority in order to satisfy the spirit of the JRS. We don't know yet whether there is going to be any clawback provision, but it seems to me there must be some option in mind by the government or HMRC to make sure that these funds aren't being misappropriated.
Yes, I think that's right, Helen. Certainly I've read about provisions where the government have reserved the right to conduct audits in relation to what the money is being claimed for, in relation to whether employees are actually working or not. So whilst I think it's right that everybody's wanting to act on trust whilst we're in a time of national crisis, the government does seem to be aware of the fact that they may need to follow up and look at what's happened with this money. And this is again where I think it comes back to, we're looking at ways to make the scheme work with the insolvency regulations, and that's what both judgments talk about, trying to make this happen and just trying to find the route for that to be done. Just one more question on Slido. Can the administrator terminate contracts of employees and then subsequently make payment to them under the scheme without adopting the employment contracts? One way in which I thought about this question is whether you were asking, can they take employees back on? So of course we know from well, the guidance that's been provided, or more importantly updated guidance, that if somebody has left you, say on the 15th of March, and then can't be taken on in a new job because they just don't have the capacity and they wouldn't be able to place you on furlough, you can actually go back to that old employer. I don't envisage that's something that the administrator would be wanting to do. But Helen, I mean, what do you think? If the contract's been terminated, what position would that leave the administrator in making any claim for this money?
Well, if it's been terminated before a claim has been made, clearly the employee is not going to be eligible for the furlough scheme. So I don't think that's what this question is getting at. It seems to me it might be a question of whether the administrator terminates the contract after an application has been made. They then receive the money into the account. What do they do with it? I think that links back to the answer to the previous question. What's the purpose of this payment in? And again, I think it's something that paragraph 66 can answer, making payments out of priority. It does bring to mind, though, the issue, I think Snowden talks about it in Carluccio, that both the act of making the application to the JRS and then paying the wages might lead to an adoption of the contract. But of course, if the contract's been terminated, is there anything left to adopt?
Yeah, I think absolutely, and it's looking at, you know, what does this happen in the first 14 days? Does it happen after those 14 days? Therefore, can adoption happen at all? I think is important to bear in mind as well. I think we just had one final question that we're able to deal with in the chat. We've been asked why the decisions aren't binding. Well, certainly in terms of what Mr. Justice Snowden says in the Carluccio's decision, I'll just read it out to you. It says, due to the urgency of the matter and the difficulties of liaising with employees in the current situation, it was not, however, possible to arrange for any representative employees or other interested parties to be joined to the application. As a consequence, I cannot see how my decisions and directions as to the law will actually bind any of the affected employees or the government. Given that position and lack of information about how the scheme is to operate as a matter of law in an insolvency, I considered whether it was appropriate to give directions to the administrators at all. Luckily, he does go on to. So I think it's about saying he's only looking at a snapshot with a snapshot of the input, but he's doing the best he can with that information. But it would be open to a wider field of individuals to take issue with this, provide more views. And what he's saying is, well, you can say I'm wrong there, and that you're not bound by what I've had to say, because I've not been able to have everybody's opinions on this. Similar sort of thing in Debenhams, Helen?
Yes, precisely the same reason.
Yeah.
The government was on notice of the claim. I think they were in Carluccio's as well, but they didn't participate. There was only representation from the administrators. There's comment in the judgment to say that they did their best to provide all competing arguments, but clearly, more so than in Carluccio here, the administrators went with a specific purpose, seeking a specific declaration. So on that basis, because there wasn't competing argument, Mr. Justice Trower said, I can't bind the government, I can't bind the employees, but here's some direction to assist you. And in fact, both judges say in the conclusions to their judgments that at this point in time where everybody's uncertain about the way forward, it was really a function of the judiciary to give that assistance wherever they could.
Fantastic. Right. Well, thank you all very much for joining in. Oh, sorry, I've just heard someone comment. Anton Smith said, I thought I heard that an appeal to Debenhams was heard on Wednesday with judgment due today. Certainly, I'd read that Debenhams was the one that was talking about being appealed. So if we do get judgment, I think that probably gives us our topic for the talk next Friday, doesn't it? If there's anything to be said on this, of course. So thank you very much for your involvement, and thank you for those of you that put the questions on Slido in advance. It does help us with all the different formats that we're managing here, not to miss anything in the chat function. As I say, we'll get the slides sent out to those of you that have joined in, or anyone else that has said they're interested. I think we might have had more participants than, or more interest than we're able to have participants. We've recorded this, and so it will be available on the website soon enough once we're able to upload it. As I say, have a look at anything else we've recorded in the past. Let us know if there's any other topics, either in employment, business and property, the overlap there that we can help you with. Feel free to get in touch with any questions, and we hope to see some of you again next week on perhaps the appeal on the Debenhams case. Thank you all, and have a lovely weekend.
Thank you.
Thanks, Laura.